My Lord, the Chief Justice had remarked that the 62 judgment of Sayyidna was, my Lord, between the Sayyidna and the government. And probably, my Lord, members of the community were not there, is your Lordship's remark, my Lord. This could be like Order 1, Rule 8, etc. So I just wanted to say, my Lord, in that case, the Sayyidna represented, my Lord, the community. And what is most important is, my Lord, I put it in the note, 5 pages of the judgment are devoted to an intervener who, my Lord, took the same stand as the respondents are now taking. That he has no power of excommunication, he is, my Lord, doing this, that, and the other. All that, my Lord, is cited there, number 1. Number 2, my Lord, I am, my Lord, an intervener in Sabarimala. I am also an intervener in the 1986 writ petition, which, my Lord, is a challenge to the judgment. From Mirajkar downwards, my Lord, and the Chief Justice's judgment in Satish Misra has taken the view that you can't have a writ, my Lord, against a judgment of the court. I have also now put it here, my Lord, curiously, that writ is by a proclaimed so-called body, my Lord, a board. It was not registered, it had no members. It had one protagonist called Asghar Ali Engineer. So, my Lord, he acted for his own board, he has no followers, and he was petitioner too in that 86 writ. He died, it was taken over by another person, I have named, he is also died. So, really speaking, my Lord, the writ has abated. There is nobody in the writ now. There is nobody in the writ, my Lord, and therefore there is no real point of, my Lord, looking at that writ, etc., etc. And finally, my Lord, as the Lordship says, my Lord, call has already told you. I just wanted to tell you, my Lord, that judgment of Sayyidna is, my Lord, a very strong bench and a very strong bar. If your Lordship sees the names, very strong bench, and the bar was represented by K. Munshi, who was a member of the Constituent Assembly, Attorney General, Solicitor General Mr. Sanyal, and my Lord Daftari. So, my Lord, it was a galaxy of lawyers, my Lord, who were there. The bench was also strong, and the intervener, the 5 pages are devoted, my Lord, from pages 301 to 306 of the report to the intervener, my Lord, who was represented by a well-known lawyer, my Lord, of the Supreme Court called I.N. Shroff. He started Shroff and Company, my Lord, originally, as he passed away, my Lord, early. That's, my Lord, a part of the judgment. So all this I have put in, my Lord, here. And that's all I want to say. So just one more thing. Kindly note, my Lord, that writ, my Lord, of 86 is now tagged here by Justice Oak's order of 2023, which is, my Lord, 5 judges. He has tagged this writ only for 2 issues, my Lord. Issues 3 and 4.
Interplay.
Which is, my Lord,
Interplay.
no. Which is, my Lord, whether 26 is subject to other parts of the Constitution. And the next 4 is constitutional morality, because that wasn't there in 86, my Lord, when they read. So it is referred only for these 2 issues, 3 and 4. That is why, my Lord, we are here. We are not on facts. Call has already told you, and I put it here. The last 75 years, my Lord, there has been no excommunication. And the last known judgment of excommunication, the Privy Council of the 30s or 40s, where they read natural justice, etc. into it. It's not, my Lord, some diabolical, my Lord, want that he has, I will do this, I will do that. Not happened at all in the last 75 years. That's the position. I am very grateful.
Thank you.
And to my friend, my Lord, for allowing.
Yes, Mr. President.
May it please your lordships. My Lord, I have a brief note, and I plan, my Lord, to answer some of the questions, but more importantly, rejoin to the various points raised. My Lord, in para 3, if your lordship takes my note, I've just summed up very prettily. My Lord, there were 4 submissions. The first is that the judgment of the High Court of Gujarat is erroneous. My Lord, it dismissed the petitions. It relegated the petitioner to a civil suit on the ground that the matters required evidence. My Lord, the majority said that if she is still continuing her faith as a Parsi and has abstained from carrying on Hindu religious rites, it's a matter of evidence, and that should be established before a court for a declaration. The minority judge said that if this is a custom which is based upon religion, namely the exclusion from the fire temple, as well as the Tower of Silence, it needs to be established by evidence. So unanimously, my lord, all the three judges relegated the petitioner by way of a suit. That's, my lord, the summum bonum. But, my lord, I have only given the facts only for the sake of orderly refutation. I sincerely urge, my lord, that we don't have to go into the facts of these cases. I want to deal, my lord, with the more substantive points which have been argued. And, my lord, I see that there are 3 points which need to be dealt with. The first is, my lord, is the right located under 25(1) of the Constitution, or is 26 capable of an independent, fulfilling existence? This is, my lord, somewhat important, and it is critical. The second, my lord, is whether the principle, what I call, my lord, is plural grounding. My learned friend, Mr. Dhawan, has referred to it as assimilative interpretation of reading 14, 19, 21 together. Whether that principles of all the articles being read together in respect of 14, 19, and 21 would a fortiori apply to the landscape of these rights? That is a very critical question. And, my lord, I'm going to persuade your lordships that it is otherwise. So, my lord, this is the second point. The third one, my lord, is this question about religion and religious denomination. And, my lord, I maintain that religion in Article 25 means established doctrine of faith as is understood in common parlance like Hinduism, Islam, Sikhism, Jainism. That is religion, religion per se. Denomination, my lord, are those who belong to that faith. Those, my lord, who are Hindus, who belong to Hinduism, come together, establish an organization. That, my lord, is a denomination. So, my lord, the suggestion that there is an attempt to extrapolate the expression religious denomination to the entirety of religion as if they are co-equivalent, that is not entirely an accurate submission. The 2 words have different meanings, and I'll presently, my lord, demonstrate that. Now, my lord, I also wish to point out that in our Constitution, my lord, it is a misconception that we have something called hierarchy of rights. It is a misconception. All fundamental rights, my lord, are fundamental rights. They are entitled to equal protection. They may sometimes collide with each other, but then we have, my lord, certain useful tests to keep in mind while examining those questions. The reason why I say this, my lord, is the principle of whether you call it single proportionality, or you call it dual proportionality, or you call it fourfold proportionality, based on, my lord, a judgment in England, rendered in completely different circumstances. My lord, those are principles in relation to judging whether a right is breached and whether the measure taken is proportionate or is disproportionate to the right enjoyed by a person. My lord, they have, and I admire Indira Jaising for her very intellectual, authentic position which she took yesterday, when she said that this fourfold test has nothing to do when we are interpreting 2 articles of the Constitution. Can your lordships imagine which part of that fourfold are you going to apply in 25(1)? Which part of that fourfold? Which part of that fourfold are we going to employ, my lord, in 26? It is incapable of application. And therefore, my lord, the question which your lordships have to deal with is that is Article 25 and 26, they may be interconnected, there may be some overlap, but, my lord, they are capable of operating in distinct spheres. If they operate in distinct spheres, I can persuade your lordships that there would be no tension between the 2 articles at all. Well, Lord, if there is no tension, there is no conflict. If there is no conflict, even the question of harmonization may not arise. But, my lord, harmonization is a sound rule when you find that there could be a mild tension between two competing rights, but the principle of harmonization is that both rights are given equal measure of respect so that both survive. The principle of harmonization is not, my lord, a principle of precedence or eclipse. That's one part. My lord, lastly, I want to deal with a point which Honorable Justice Varale mentioned in one of the hearings. It was a very valid point about rationality. And that question, my lord, has stayed with me throughout the hearing. My lord, the submission which I want to urge for your lordship's consideration is the scope and the length of judicial review for 25 and 26 is not the same scope of judicial review under 14. In other words, an irrational factor which borders on extraneity or which borders on extreme irrelevance. My Lord Justice Sundaresh mentioned it the other day. That is relevant for judicial review vis-a-vis 14. But in the scope of 25 and 26, my lord, you may employ rationality for the purpose of logic of inquiry and determination in adjudication, but the tests of rationality are not those of 14. This is the, my lord, I wanted to respond to that. So this is not the area which I seek to cover. My lord, may I straightaway invite your lordship's attention to the reasons why I say this. Please come to page 5 of my submission.
Yeah.
Exactly. Thank you. My lord, I'm grateful to my learned friend, the Solicitor General, my lord, in more ways than one. My lord, Article 14 is the very antithesis of arbitrariness. That concept of arbitrariness or irrationality is quite distinct, shall we say, from the area of personal freedom under 25(1). Now, my lord, how do I distinguish 25(1) and 26? 25(1), my lord, is a wide, vast expanse of individual freedom. It's so wide, it's so vast, because, my lord, there are many stages of belief. There can be stages of disbelief. There can be stages of partial belief. There can be stages of withdrawal from belief. All these, my lord, are a part of the journey which you undertake under 25(1). Simultaneously, my lord, you could move from one teacher to another, to another, to another. It is not that, my lord, the universe of religion is exhausted by any one particular doctrine. You have any number of, shall we say, permutations and combinations on the religious tenets, and more importantly, on what could be the outcome in terms of inner personal experiences. All this, my lord, is protected under 25(1). This entire width is protected under 25(1). And, my lord, there we have to treat conscience as somewhat independent even of religion. Because conscience, my lord, is a faculty of final, shall we say, discernment. But it need not necessarily be religious discernment. It can be moral discernment. Moral discernment would imply conscience. Religious discernment, my lord, is a slightly different subject. That is proper freedom of religion. And, my lord, here, that judgment, that is the judgment which my learned friend Indira Jaising referred to, the judgment in the 80s of whether a person who was a Shudra could become a sannyasi. That judgment, my lord, is a significant judgment because it tells you about the movements within Hindu society itself, why people took recourse to an ascetic way of life as a reaction to the practices in relation to exclusion on account of caste. And that, my lord, is a very significant judgment, because there it said that a particular order, which strictly, my lord, did not belong to the Shankara, the Dashnami order, but still emulated some of the traits and aspects of that order, was entitled to follow the same principles of succession to Mahanship. So, my lord, the question is, you do what is called a Viraja Homa when you actually renounce the world. And they said that in that case it was done, and therefore, my lord, therefore he was entitled to succeed. But it is, my lord, a good historical account of how, my lord, movements happen within religion. My lord, in 25.1, why is it that the collective is not yet there? This is the question. Everybody said 25.1 is the repository of the individual, 25.1 is also repository of the collective, and 26 is actually no more than an elongation of 25. And if 25 is subject to, well, other provisions of part 3, then why shouldn't 26 be subject to part 3? Well, that is the argument. Now, my lord, if 25.1, and my lord, it's very significant that there are 3 principles your lordships will keep in mind. One is an interpretation by which the fullness of the right is upheld is an interpretation which you would prefer to an interpretation which attenuates or diminishes the content of the right. My lord, this is the first point. The second is, my lord, if the words of the Constitution are clear, then, my lord, there is no scope for applying the theory of implied limitations when the intention to express limitations is manifest in the text of the article. This is, my lord, the second point. And there is a third point. And the third point, my lord, is the nature of individual freedom under 25.1 is not, my lord, the same as a denominational freedom under 26. The individual, my lord, can be religious one morning. He can be less than religious the next morning. He can actually meditate in whatever way he is taught or he likes. He can read, my lord, any kind of literature to inform his mind. And, my lord, we are very blessed to have varied quantity of literature written by so many scholars and, my lord, people who are experienced in the field. My lord, that's a wide panoply of experience. But once you are a denomination, you subscribe to a fundamental position of faith. It might be a doctrine which is just universal. My lord, as my Lord Justice, the Chief Justice said, if 10 people in a village, my lord, came together, designated one bottom of a tree and lit a lamp, they could well constitute a denomination, depending upon their faith. Therefore, it is when you are a member of the denomination, you tell yourself and you tell other members that we follow certain tenets. Now, my lord, naturally, there the expression established
determination. So what is a faith of a denomination is definitely justiciable to that extent, but not on a merit or value judgment, as you are saying, in review.
My Lord, I cede the point that judicial determination as a fact is entirely permissible.
A state of mind.
Yes, yes.
State of
including-
mind
Because
is
even belief.
definitely something which is within the court's domain to decide.
My Lord, I entirely bow down when in fact, my Lord, it is through an evidentiary process. At that time, the basic beliefs are set out for the purpose of enabling the court to be apprised of what exactly is the injury which is being complained of. So for that purpose, my Lord, certainly courts have jurisdiction. What I meant is, extra further, shall we say, my Lord, beyond adjudication or determining a state of mind as a fact, further value judgments, my Lord, are outside the purview of this. But now, my Lord, I come to the next point, which is it simply hands-off in relation to matters of religion, or can you also seek assistance in cases? This, my Lord, is important because I'm sorry. My Lord, I wanted to urge for your Lordship's consideration. You may need assistance because, my Lord, as I said, all temples in this country, or my Lord, all places of worship do not follow a uniform pattern. So, my Lord, what is relevant for an archaka in place A may not be relevant for a person in state B, maybe an adjoining state, but it can happen in reality. Therefore, I'm saying, my Lord, with respect, that keeping this in mind, there may be occasions when your Lordships would like at least some prima facie case in relation to the assertion of a religious right. But as my Lord the Chief Justice very perspicaciously observed yesterday, that once that initial burden is discharged and a prima facie case is made out, then it is up to the person who is either invading the right by way of an executive measure or by way of a legislative intervention, that they would have to justify how is that justiciable, how is that justified. So, my Lord, this is one important aspect. What your Lordship said is that if there are matters of detail in relation to a religious practice, there your Lordships would defer. And, my Lord, I use that word defer with a qualification. When called, when, my Lord, suitable, when appropriate, you would defer. So, my Lord, whenever it is appropriate, you would defer. You would defer to the wisdom of the denomination about the way in which, my Lord, the various traditions and ceremonies and forms of worship and instruction are given. So, my Lord, this is one important aspect.
It is usually when there is an encroachment or an invasion into that, the question would arise.
That is when a question would in fact arise.
Yes.
Now, my Lord, I deal with two more points. One is Maneka, because, my Lord, there, with great, profound respect to my learned friend, the solicitor, my Lord, I hold him in the highest esteem. My reflection, my Lord, is that the judgments in relation to the conjunction of fundamental rights like 14, 19, and 21 in Cooper, Maneka Gandhi, Minerva Mills, Coelho, my Lord, they do not operate in this sphere. If your Lordships read the Constitution, even in respect of fundamental rights, as dealing with different spheres, then, my Lord, we would get a correct answer. Because in the very nature of things, my Lord, the right to religion under 25(1) is really, my Lord, in some sense, contrarian. It can be contrarian to the principle of reason in 14, because it's an act of transcendentalism when you really seek to commune with a deity or with your inner self. My Lord, these are different dimensions. They are not dimensions which can be tested by secular touchstones or secular yardsticks like Articles 14 and 19. Well, this is a little important. And I'll explain why, my Lord, 25 and 26 have the requisite protections within themselves. 25 and 26, my lord, are unique provisions. 25, when it uses the word subject to the other provisions of this part, my lord, it uses them with a conscious purpose. It is not that it is bereft of purpose. It would be incorrect to read it as bereft of purpose. But what is that purpose? The first is, my lord, other provisions. My lord, other means it excludes 25. But that right under 25 is subject to other provisions of this part. The other provisions of this part can be divided into three categories, my lord. Three categories. The first are the rights which follow 25, namely 26, 27, and 28. Because, my lord, even they protect individual freedom. They protect against intrusive religious instruction. But they also protect a donor, a man who created an endowment. And one of the conditions of his endowment was that there should be religious instruction. They said religious instruction can be insisted in such an institution. So, my lord, your lordship sees Article 28, 27, they balance both the freedom of the individual and they also give effect to, my lord, the purposes of endowment if it is religious instruction. So, my lord, it is completely even and it is balanced. So, my lord, one set of rights to which Article 25 is subject are the rights in 26, 27, and 28. This is one part.
Because they are manifestations of
The right to religion.
under 25(1).
That's right.
And they have to be given their full meaning.
Yes.
So,
And, my lord, that is why you find these words: worship, instruction, religious worship, religious instruction, matters of religion, religious practice. My lord, all of them are comprehended within religion. Whether it is under 25(1), which a man does in his home, or it is, my lord, someone in a denomination who does it in a denominational setting. So, my lord, I submit with respect that it is clear individuals have a right of freedom, denominations have a right of freedom. And that brings me, my lord, to the next question. I said there are three sets of articles in
Mr.
part three.
Subramaniam, by your logic, 29, 30 would also come into
They would, my lord.
Yes.
In a manner of speaking, if you have to
with
extend,
regard to
Yes,
minority
yes.
institutions, because the word equally now
Equally.
will stand
Eh.
with a balance or a handicap in favor of the.
favor of the institution. And, my lord, I submit that if we read these articles together, you get a picture that the landscape of this is quite different from, shall we say, positions of vertical interplay. My lord, I really think vertical and horizontal is an oversimplification. Shall we say, in matters where you enforce rights against the state, or in areas where the state guarantees you fundamental freedoms, this, my lord, is a different set of rights where you enjoy your freedom of religion and you also enjoy the status as a minority.
yes.
So, my lord, really speaking,
So other thing of subject to other provisions.
Yes.
In all probability.
Yes.
Would also read in the
Yes.
reasonable restrictions of 19.
now, my lord, let's look at that. May I, my lord, your lordship is coming very close to the, shall I say, to the end of it, but I'm taking your lordships through a slightly different route, if I may. But I have noted, my lord, there is some element to be observed in this because,
Although it's a special fundamental right of religion and conscience in 25(1) and a right of a denomination of 26, they seem to be subspecies of 19(1)A and 19(1)C.
now, my lord, let's look at that. I'm very grateful. I'm very grateful. If suppose, my lord, we did not have 25 and 26, there could have been a question that whether 19(1)A itself comprehended, because freedom of expression can also mean freedom of expression through your conscience. It can also mean freedom of association could as well.
We have done some degree of reverse driving in 19(1)(a) by saying right to information is inbuilt in right of expression. Now, if right of expression includes information, then it is definitely including conscience.
Malad,
Without a conscience, a person would not be able
Malad,
to.
that is why, Malad, this word conscience, if I may say so, can apply not only in relation to matters of religion under 25, it may apply whenever you are having any interaction, Malad, any transaction with the world or with in any form, there may be an element of conscience. That goes without saying.
You may.
Administrative law, it is very important.
In
Conscience.
Malad, that is why, Malad, I have some difficulty with the formulations, the three formulations of Honorable the Chief Justice Chandrachud in that electoral bonds case. The first, he believes that there could be a hierarchy of rights. Second, he actually says that 25 tells you that it is subject to Article 19, it is subject to Part 3. Because it is subject to Part 3, it is inferior to the others. Malad, there's a suggestion in the judgment. It's not correct. But Malad, what I am concerned is, when you are wanting to interpret articles of the Constitution, you don't interpret the articles with reference to tools of judicial review, which are in the context of assessing effect of, Malad, executive action or legislative action. You take the articles themselves and you take the articles as plenary if they are rights. And if they are rights, now the question which my Lord Justice Bagchi has put to me is, aren't religious freedoms or 25 a species, and my Lord, I take that word seriously, a species of the general freedoms in 19?
No.
My Lord, I submit with respect. My Lord, my respectful submission is that there is a distinction. The distinction is, my Lord, I'll tell your lordships the distinction. The distinction is this freedom under 25 is a subjective freedom. It is ensured by the state. It is also, my Lord, laterally available. But, my Lord, laterally, you assure the other citizens of their fundamental rights. Laterally, you assure other citizens of, my Lord, respect for their rights. So how do you, my Lord, practice equality, tolerance, coexistence of all religions? Unless you have these subject to other rights in Part 3, because there are other people. The other people may not be exercising 25(1) right at that time, or they may be exercising 25(1) right, but you need to be conscious of their freedoms, that they have fundamental freedoms. They must be respected.
Equal entitlement.
Equal entitlement, my Lord, equal entitlement of all religions to be manifested in real action is the reason why you have subject to other provisions in Part 3.
Therefore, a need for a separate article.
Now, my Lord, I'm now coming to it because your lordships will find there are 3 articles which are prescriptions. They are prohibitions. That is, my Lord, 17, 23, 24. Now, one can say, under the guise of religion, you should not transgress 17, 23, or 24. But, my Lord, the answer to that is, if you ever do anything connected with 17, 23, 24, it is not religion at all. It goes out of 25(1). So those 3 articles are standalone articles, but it is expected that anybody who exercises any right will always keep these 3 injunctions in mind, my Lord. These 3, that is 17, 23, 24, are complete, my Lord. They are prohibitions to be observed religiously.
It cannot be a part of conscience then.
That's, my Lord, neither conscience nor religion.
Yes.
So it steps out, shall I say. So there is no conflict. The point I'm trying to make is, my Lord, so viewed, 25 is conflict-free, 26 is conflict-free, the other articles go with it, and therefore, my Lord, that 14, 19, 21, the trilogy, why doesn't come walk in 25-26 is because the space occupied in 25 and 26 is of a substantially different character. It is of a personal, experiential, subjective.
Can we put this way? The religious faith of an individual to reach the ultimate come necessarily along with the tenets of the denomination.
I completely agree. I couldn't have put it better. I completely bow down to your lordship's observation. This is, my lord, really the sum and soul of the constitution, which is why, my lord, this right 25, 26, if we read other implications or other rights in it, you will have what is it you will be able to do? Because you have to be free to be able to even do what you want to do under 25(1). And as I said, my lord, there is no unilinear passage to the ultimate, as your lordship said. It is full of twists and turns, and there are many trials and tribulations. Nothing, my lord, happens in that journey easily too. If that is so, my lord, this is one of the most sacred freedoms which has to be preserved. And if this is central, my lord, to the existence of a human being, namely conscience. Now, my lord, can we make conscience? Let us take the case. Can we make it subject to what we call as intelligible classification by intelligible differentia with a rational relation to object? No. Because, my lord, the space of faith is intrinsically different. It's a completely different freedom. Its freedom, my lord, does not qualitatively ever come close or akin to, and that is the answer, my lord. It does not come entirely akin to, shall we say, any of the freedoms under 19. But now, my lord, I want to answer a question.
19 and 21 are essentially against the state.
They are, my lord, they are substantially, my lord, against the state. The fact in some judgments, your lordships have said that they could have had horizontal implications does not make them horizontal rights interposing their way into 25 and 26. My lord, that horizontal is, again, it has to be, my lord, read within a boundary, that expression horizontal. That word horizontal does not imply that it seeps into all these rights. The reason, my lord, why the individual and the collective are different is the collective has to adhere to the tenets and he has to actually function, as your lordships pointed out, A, B, C, D, different yardsticks in A and B, C and D. That is why, my lord, that along with what Justice Bijon Mukherjee, what Justice in Devaru said, under 25(2)(b), which your lordships could see in Shiru 25(2)(a). So therefore, my lord, 25(2)(a), 25(2)(b) exhaust the universe of limitations by legislation. Simultaneously, you have, my lord, that public order, health and morality. Although, my lord, public order, health and morality may have different meanings in 25 and 26. They need not necessarily have the same meaning in the facts of a given case. They can have slightly different implications. But to be fair, my lord, there was one question which my Lord Justice Bakshi asked, namely, if suppose somebody disagrees with the tenets of a denomination, should he not have the right to express his views? Well, now I'm looking at a 19(1)(a) intersecting in the space covered by 26(b). I'm testing, my lord, the position that do rights of individuals get diffused into some sort of totalitarian oligarchy, which is called the denomination, and they cannot express themselves. My lord, as I said, even denominations are meant to behave with sensible approach, and if they do, they have to welcome debates. As your lordship said, my lord, the reforms which happen in society happen within society, from society. Right from Raja Ram Mohan Roy, my lord, every one of them has been a reformer within society. The whole Brahmo movement, my lord, was indeed, it was a rejection, my lord, of all outmoded forms of worship. Even, my lord, the teachings of Sri Ramakrishna were revolutionary in his point of time. They were completely unique. My lord, the teachings of Sri Aurobindo, logically, my lord, I agree with the Solicitor General that if you apply the test of denomination liberally, followers of Sri Aurobindo, who, my lord, believed in supramental consciousness, my lord, there's that book called The Ascent of Man. It's one ascent of man. And his collected essays on Gita, my lord, again, prolific scholar. His poem, my lord, epic poem, Savitri, is something which would match with Milton's Paradise Lost any day. So, undoubtedly, your lordships are right. The same principle has to be followed. Now, why is it, my lord, I'm saying denomination, please give a liberal interpretation.
There need not be a rigid organization as such.
My lord, it is an organization, it's a registered society.
Necessary.
My lord,
It is
I understand.
necessary to have a rigid organization.
No, my lord, it's not necessary. But, my lord, organization, they said,
If a collection of people following
yes,
particular, you see, type of faith,
yes.
if there is no rigid organization, can you say they are not a denomination?
No, you cannot say for want of organization, but I must tell your lordships, as a matter of fact, in the Sri Aurobindo case, there was a proper registered society. It was called the Sri Aurobindo Society, registered in Pondicherry. And that is where, my lord, the books were published, the printing was done there. And, my lord, this is one of the, if I may say so, therefore, the threefold test in Shirur Math is very easy to fulfill, my lord. So please don't think that it had to necessarily follow a unique teacher with special qualifications, because, my lord, if your lordships don't agree with my interpretation of a widespread definition for denomination, denominational temples will lose protection under 26. My lord, that is a very serious consequence. Denominational temples, my lord, the right to pursue religion by groups is a substantive right under the Constitution. It should not be defaced by interpreting the word denomination, that you please tell me what is exactly the Siddhanta which you are following in a given case. That is why, my lord, I said, if your lordships read the word religion as established faith, that is various religions, and you read religious denomination with religion, it's clear whoever belonging to whichever faith coming together. My lord, it will completely solve, shall we say, all this about a denomination. Now, my lord, I want to quickly finish. My lord, just two more points. My lord, I now want to say one thing, my lord, about 14, 19, and 21. I have made the point. But, my lord, I must say that the judgment in the electoral bonds case, employing the fourfold test of proportionality, my lord, is not necessarily the only way to interpret articles in a constitution if they are coming into tension with each other. My lord, that is not the only way. And that way, my lord, is actually very unique, my lord, to the European Court of Human Rights. And because England was a party to the Human Rights Act, and therefore, my lord, as a public authority, Baroness Hale, in the judgment, my lord, in Campbell versus Campbell, had to undertake what is called the balancing test. My lord, their rights are worded that you have to balance. There is nothing else you can do, but you have to balance. But yes, conceptually, my lord, there may be a need to balance. And that is why, my lord, Devaru is a judgment which did not use the word proportionality. It used the correct word harmony. And harmony, my lord, is the quintessence and the soul of the Constitution. My lord, as far as the facts are concerned, I have stated them. I don't think I'll take a moment more.
Thank you, Mr. Thank you.
Grateful, my lord. If your lordships have any questions, I'm more than happy.
Thank you very much.
Thank you.
Some doubts are solved. Some doubts are solved.
I'm grateful, my lord. I'm grateful. And, my lord, I must thank Ms. Jai Singh for enlightening us with an extraordinary address. It was truly extraordinary, memorable. And also my colleague, Dr. Dhawan, who, my lord, inspired me with many of the ideas. I'm grateful to him. That's how it has to go.
Yes. Lord, the arguments on the other side boil down to one proposition and one only. And it is from that proposition that everything else emerges. The proposition is that there is an assimilative way to read fundamental rights. Now, this assimilative way started in 1970 in R.C. Cooper, went into Maneka Gandhi, went beyond in Minerva Mills. And this is responsible, Lord, for a large part of the interpretive problems that we have. If everything can be assimilated one upon the other, 21 will be read into 26, into 27, into 28, 14 will be read into 21. The so-called horizontal rights, I don't like the word horizontal rights, my lord, because in sociology we mean it as vertical and horizontal, but anyway, we'll use it. Horizontal rights will be read into everything, and that assimilative interpretation would in fact destroy the entire construction of fundamental rights. I'll elaborate that later, but let me begin, my lord, by more generally on where we are in agreement. My lord, we have a huge constitution. I have divided it into 10 texts. I won't bother your lordships with all of them. That's the only way to read it in my view. But I'm going to concentrate on two texts of the Constitution: the justice texts and the political texts. Your lordship is concerned here with the justice texts. I'm not saying that Parliament is not concerned with justice texts. Of course they are. When your lordship exercises the justice texts, there are a huge apparatus of concepts that you can use when you are balancing, when you are using proportionality. Double proportionality is actually taken from algebra, but whether you should use it or not is another matter. And therefore, my lord, when your lordships are looking at the political texts, your lordship exercises the rule of law. That is what your lordship is saying to them. You have been given power by the Constitution. We will not let you cross the rule of law. Therefore, there is a fundamental difference between the custodian. I can actually see you, my Lord Justice Amanullah. Where I was sitting, this actually, I could never see your face. But I can now. I'm grateful for it.
I hope it's not a distraction for you.
It's a very pleasurable face and nice to look at.
Thank you.
Unless you ask me angry questions, which is another matter altogether. But at any rate, just bear this in mind, that you are not exercising jurisdiction over the political texts. I'm not saying the political texts are not important. They gave us the basic structure doctrine. They gave us the doctrine of nexus. They gave us the doctrine of colorable legislation. All that was yours. Where we are on common ground, starting with Ms. Jessing, this is in fact a social document. It has a social document going into futuro, and it is a social document of the most diverse country in the world. No other country has to adjudicate the problems that your lordships has to adjudicate. Kindly bear in mind, that is why I am very averse to pulling out precedents from other countries unless they help conceptually. We are also agreed that the reform process is the most important process in the minds of the Constituent Assembly members. And this goes to the interpretation of 25(2)(b). Probably it's autonomy, but this goes to that. And there we are also agreed. Mr. Sanjay Hegde was right in going back to 1926 to trace the movements that had taken place. And my Lord Justice Baravale then corrected one or two aspects of it. So alongside, if this country does not do social reform, it is lost. It is lost totally and completely. My third point, my Lord, as far as this is concerned, this country does not just exist for individuals. It exists for groups and institutions. And I will demonstrate that. Written into even the fundamental rights chapter are the rights not just of individuals, but groups. As soon as you come to 15.3, you come immediately to the concept of a group. And how many do we have, my Lord? And how many do we have to offer? SCs, STs, EWSs, women, children, the degradation rights, they all belong to groups. Unfortunately, what has been argued from the other side is a massive investment in the concept of the individual. And 26 is a group right. 29 is a group right. Call it horizontal, call it whatever you like. 30 is a group right. And now, my Lord, I'm trying to go back into what was in the minds of the constitution makers. Let us look, my Lord, at the grouping of the articles in 25. If I can find it, otherwise I'll ad lib, my Lord. Firstly are the libertarian and the egalitarian rights, 14 to 18. This was uppermost in their minds because if these rights were not given, then the entire freedom movement would have come to naught. Because speech was taken away. Unfortunately, sedition, my Lord, is there still. Speech was taken away. Equality was taken away. All this was taken away. So if they did not have these libertarian rights, the very promise of the Constitution would disappear. And I therefore put it in that context, that this is one particular area, and I don't want to read one right into another and one area into another. Now, my Lord, by and large, your lordships have resolved the questions of 14 to 18. This is no longer controversial. Possibly Kaushal was the last case where such controversies had to be resolved. And your lordships have to, I mean, we on this side are still concerned with preventive detention and bail, but that's another matter. Your lordship has to resolve that as well, because that is also part of 14 to 22. The preventive detention provisions have not been given the presence that they had in the early 50s after Atmaram's case was decided in 1951. Now, that was the first object related to the freedom movement, to give protection to everybody and equality to everybody. Then comes, my Lord, what else did they think of? In my view, they thought of religion as groups and religion as individuals. And so they gave rights, and your lordships and ladyship are right, it goes all the way to 30 in one sense. But I'll separate them in a moment. As far as the Article 30 rights were concerned, your lordships have resolved those as well. We are now in a very interesting situation. TMA Pai, followed by Nagaraj, has made it abundantly clear as to what the direction should do. You will be faced with political questions as to whether you can go beyond 50% or 70%, but the foundation of that has in fact been laid. The third big area was the area of school, language, and religious education. That area is also been resolved by your lordships, TMA Pai, and everything was followed from it. The one area that remains unresolved is the right to religion, going all the way to 30. And that is what your lordships have to resolve, in my respectful view. I realize that in the complexity of India, this may not be possible, and it is certainly difficult. I use the word balancing as the decisions taken by your lordships. The rest are techniques. Balancing is that difficult part of judicial decision making, which your lordships, my lord, have to look for, find within yourselves. That very famous passage, my lord, by Justice Patanjali Shastri in V.G. Rao, where he says, and also the conscience of the judge. Now, we cannot, my lord, lecture to your lordships on how balances are to be worked out as an interpretive tool. That is your job, and only your job. You have the experience to deal with it. So let me come back, my lord, to this. My lord, it is said, and I borrow this from Walt Whitman, that India is so complex. To borrow his phrase, It was the biggest mutt in Bengal in the Mohammedan period. It traces its period to the Mahabharata. There had been a lot of litigation in regard to this mutt in the district court and in the high court. Most of the properties of the mutt have vanished because of either mortgages or sales or long leases and the like. Another instance of this kind is the Takeshwari mutt. Court schemes were prepared, and as a result of certain complaints regarding the working of these institutions, within a few months thereafter, litigation commenced. Third line from the bottom, most of the mutts in the north, as well as the south, were maintaining pathshalas, tolls attached to them for the propagation of Sanskrit studies. They were running religious charities like gosalas, dispensaries. Most of the pathshalas are now closed down for want of students and are not maintained properly. To some extent, this reality may be due to the change of ideas from generation to generation, but it is also due to the fact that there is a tendency amongst many Mattapadis to treat the institutions as their private property and utilize most of the resources for themselves. Then comes 3 lines later, many are not even versed in the first principles of the Hindu religion. Not to speak of the fact that they really make little attempt to propagate or promote the religion knowledge. The need for remedying this state of affairs is a matter of urgency, and the steps that we consider read that. Next paragraph. All mutts served a purpose according to Hinduism. And then the third line, but mutts managed to secure large powers of property at their disposal in the British system. Then, my lord, about 8 lines from the bottom, one view is that custom had been given powerful religious functionaries vast wealth, properties, powers, status, and they should retain their customary powers and privileges. The other was that they should be denuded of all the appropriate shares consistent in the limited needs. The report noted the extravagant claims by the functionaries of the Dakshina temple in Calcutta, the Nathwara temple in Rajasthan. Put on a comparative scale, they were not the worst of them. And then, my lord, they gave further examples. Then, my lord, kindly come to the page 35, second para. Many big temples and mutts were richness personified. For example, the Badrinath temple had ownership in palatial buildings in Dehradun, Lucknow, Calcutta, Bombay, and perhaps other places. Kedarnath in the previous year had income of so-and-so with surpluses. Nathdwara had jewelry and surpluses. Jain trusts also then are...
I think ultimate conclusion is at page 40, Mr. Dhawan.
Yes, no, I'm just saying in page 36 you'll find the surpluses.
That's correct. At page
No,
40.
that is my conclusion and I don't want to read it.
Better.
Because I have actually summed up this in my own words.
That's it.
I may have got things wrong, my lord. I write my own submissions and first by hand. So there may be a few problems here and there, my lord. Then, my lord, when we go and I just want to read one more, page 37, and your lordship has got the picture. That is on page 37, second para. Chief Minister B.C. Roy complained to the commission that private temples were collecting huge public donations. The Kalighat temple had huge areas by the Nawabs of Bengal, which the Shibets sold, and the Shri Krishna Mahaprabhu temple at Nabadweep was grossly mismanaged, and the 100 Shibets attached to it. The old Calcutta Kali temple belonged to the Tagore family, and the descendants not only claimed it to be private, but took advantage of the concessions from taxes as a private temple. In Assam, Baduri temples and elected Deloys made most of the money. So, my lord, it's not as if they didn't know because of one campaign. It is a major part of the reform Sometimes, my lord, we think of reform, let's have a uniform code because we can get Muslims into it. We overlook the fact that the origins of Article 25(2), social reform, has a very wide implication, and anybody who has been anywhere in India will recognize the importance and probably the autonomy of 25 to A and B. So I stop on this. As my lord, the Chief Justice puts it, there is more to read. But let me come back, my lord, to my main argument. My main argument is my summary of the argument on the other side. So this was important, my lord, for us to remember that this is one of the unsolved areas in the fundamental rights chapter. Constitution benches have taken care of other parts, but this is the unsolved area. Now, my lord, kindly come to page 2. I'll read it because it's easier to explain my view of why their basic argument is wrong. 1.1. The basic right to freedom of religion, 25 to 28, rests in the individual freedom of conscience and the right to freely profess, practice, and propagate religion in 225.1. This is not my argument. This is my paraphrase of their argument, that the nodal right is in fact 25.1.
That's why your heading shows the arguments of the respondents appear to.
That's right. That's what they've argued, my lord. And I believe that this is the basis of the argument that they have raised. And it attends everything else that has been argued. Arguendo, it is these individuals who form a community as a denomination or section. We have to make a difference between a collectivity of persons and a community. 25 is about a community. It is not about a collectivity of people who have simply gathered there and suddenly elected a leader. It has some purpose to it and has to be, as my learned friend Mr. Subramaniam said, defined widely. The next, therefore, the restrictions on 25, according to their argument, especially the restriction in other provisions of this part, also governs 26, which is argued cannot exist on its own and depends on its existence to Article 25. Therefore, their argument is 26 cannot exist on its own. In fact, Mr. Srivastava took it even further and took it all the way to 28 as well. Now, my lord, it is argued, and this is where the origins come, that the bank nationalization case, Menaka Gandhi, took an assimilative view of constitutional interpretation, supports the view that each right is not a silo. Now, my lord, sometimes we use very emotive words. Silo is a very emotive word. As if you were to say to me, Rajiv, you are a silo, I would actually be very offended. C.L. Stevenson, in a famous article in 1939, said this is called persuasive definition. So as soon as you word the silo, suddenly you say, what's happened? Can articles be silo? No, they're not. They're independent and autonomous. Therefore, it is argued, constitutional morality has to be read into 26, not just as interpretive values to be considered, but as a limitation on the institutional rights bestowed in 26. This is a further consequence of this assimilative approach. The doctrine of essential practices is useful so that only the core of religious rituals and practices weigh various factors and values to come to a decision on law and determine outcomes. I think this is what Justice Bagchi had in mind, that this process is to determine outcomes. It is not the methodology through which we reach the decision. It entails considering the rights against the restrictions using various juristic techniques such as reasonableness, proportionality, double proportionality, due process, and the concept of a just law. Although Indra Jaisingh didn't specifically advance this, I accept what was implied in what she said, that when we talk of law now, we talk of a just law. And this should be, other things remaining the same, using a ceteris paribus clause. This is how we perceive law after Maneka Gandhi, Cooper, and others. So, my lord, this is the argument, and these are the implications, and like an octopus, it spreads everywhere, every part of the interpretation. The basic argument is privacy, individual conscience, individual freedom to pursue the faith, and it is individuals who make communities, create rights, even though religious groups and institutions predate individual existence, and most are born into the faith with the right to differ, reform, or renounce it as they please. I'm a pre-independence child, my lord. I didn't choose my faith, I was born into it. So this idea that suddenly you come to a community and all of a sudden you choose it and you choose dissent in it, well, this is a falsification. Dissent does exist. You have to protect conscience. As Mr. Subramaniam put it, that conscience is something that you cannot go into. As soon as you go into the area of professing, practicing, and propagating, that is an area of judicial examination. Now, my lord, having said this to be their basic argument, if your lordship accepts that there is a centrality to it, then, my lord, there is something in what I say. If not, my lord, I give a walk over to them and take their position as. Now, what did the Constitution make us?
You are giving on the theory of constitutional interpretation.
That's right.
When it comes to these articles, because they were really not considered as such by a 9-judge bench. It was individual cases.
That's right.
There was no collective consideration earlier by this court.
That's right. Lord,
Therefore, the 14, 19, 21 triangle cannot be straight away applied is your argument.
I want to add to that, because it's a point I'm going to make, but your lordship question is a fundamentally important question. In all this assimilation, none of the rights assimilated lost their individual identity. If an Article 14 question comes to you, you will still look at classification and arbitrariness. If a 19.1a question comes, you will still look at 19.1a and 19.2.
Yes.
Only thing that you will see is that the concept of reasonableness has been extracted by this assimilated process. So when you look at 21, and the history of this court is interlinked with 21, you will look at 21, you will look at life, liberty, and law and interpret them in the context of 21. So the identity in this assimilative process is never lost. That's what I want to argue, my lord. And then, my lord, I asked myself, what did they have in mind? The first thing they had in mind, of course, was individual conscience and religion. But they were a little fearful of what the manifestation of religion can do. Not the conscience part, the manifestation. As Justice Amanullah put it when superstitious beliefs were being discussed, it's not the beliefs, but how they are as soon as you come off professing, practicing, regulating, you enter into a social area. Now, what did the Constitution makers want there? The Constitution makers said, we can't leave this as a right which does not have restrictions. We just can't. Because in its manifestations, it could give rise to the worst communalism in the world. But they added one more. Other provisions of the Constitution. Can you give me a Constitution? Other provisions, just have a look at it. It's a play on words, like Guru Swami's play on words on what is managed, etc. It may be just a play on words, but I'm bringing it to your attention. it says, and to the other provisions of this part.
Yes.
It doesn't apply to itself. If it doesn't apply to itself, how can it be transferred to 26? It says the other provisions. It was conscious that the libertarian provisions, the equality provisions, the reform provisions for women and children in 15.2, untouchability, whatever it may be, all that will apply as a restriction. Because they were not sufficient with the police power. The police power being public order, or morality, or health. And that is the reason why this had to be controlled, because we are a country with a huge amount of religious tension and group tension. And there is no point denying that we are not. Then, my lord, they faced another problem. They realized that group rights exist in India. India does not exist as individuals. It exists as groups and institutions. That led, my lord, to Article 26. And the only restriction that was placed was the police power. Then, my lord, they confronted another problem. This is a problem that goes to secularism and some conflicts between K.M. Munshi and Nehru on Somnath as well. Munshi wanted Somnath constructed, and Nehru's view was you can't do it with public money. So if you want to decode, of course, the controversy came later, but it is there in the debates. And so they said that, look, there will be no taxation for a particular month. We are a secular state, and therefore I call this a lot in my writing celebratory neutrality. Rajiv Bhargav says principal distance. These are a lot important concepts from political theory that have come. That led to 27. 28 was the biggest problem of all. Catholic schools. Lord, the domination of India for the last 75 years are people educated from convent schools. They've done very well. The others are coming up. And they were very concerned. First principle was secularism. The state, you will not, 28.1, the state will not impart religious instruction. This came to your lordships, my lord, in Aruna Roy's case. She said it was religion. Your lordship said it was culture. It had to be interpreted. But the more difficult one was, if you are not getting aid, then fine, you can do what you like. But if you get state aid, what should you do with students? Will you give them religious instruction? I went to a boarding school. Principal wrote to my father, and he said, would you like your son to attend chapel and religious instruction? My father said, oh, certainly. And so I spent 5 years in the choir, which I absolutely didn't want to go, but I learned a lot about Christianity. At any rate, that was the purpose. And in TMA Pi, Chief Justice Kripal takes the view, no school can survive without aid. All of them are aided. St. Stephen's couldn't survive without aid. Convent schools can't. And therefore, this was a very important issue. We are giving aid to all these people. And it was a point raised by Govind Ballabh Pant. We're giving aid to them, no compulsory religious instruction. So that completes. Now, what do you do with the other variety of India? 29. It is in general terms. I won't read it out. My lord, your lordship has read it over and over again. 30 is in general terms. Now here, 30 posed a problem. The problem was that Justice J.C. Shah in 1963 said that because there are no limits here, that means it is absolute. When the matter came before the 11-judge bench in TMA Pi, they said this is not correct. No right can be absolute. If they have property, property regulation will apply. If they discriminate, of course, India doesn't have a social anti-discrimination law. If they have bank accounts, all that regulation will come into this particular process. Then they had to regulate students. How many? St. Stephen said 50%. And now, of course, we have all that problem. And that you must show, the words establish and maintain are there. One controversy still remains in AMU. Was it established and maintained by the religion? But these controversies were all solved. So what was in the mind when faced with this diversity, faced with the pressures, faced with all the requirement of reform, what did they want to do with these articles? The one thing that was almost clear is they did not think of them as silos. So I complete that point. I don't want to labor it anymore. I go, my lords, into the next question. On page 4 onwards, I'm not going to read it.
In fact, you have explained well already this part.
Yep. I'm just supporting that argument, my lord, that these are the group rights that have been recognized in our constitution, with national commissions to support them all the way. And the most interesting one is Nagaland. No act of parliament in respect of religious and social practices, Naga customary law, administration of criminal justice, ownership and transfer of lands can be done by the central government without. So here is a huge range of protection. Can we put it in a silo? We can't, my lord. Next, what I come to, my lord, Mr. Subramaniam has already argued that there are no hierarchies. So I have got a page on it. I'm not going to, my lord, take your lordship's time on it. I also take the view, which was expressed by Mr. Vaidyanathan to me, and I think this had a little ring in what the Solicitor General said. Why are there so many restrictions? But I'm going to leave all that. So kindly come to page 8. Here is where I give my response to the assimilative argument. Since I've already argued it, my lord, I am not going to go there.
Yes, but
There is no point going there. The important thing, my lord, that emerges is actually at the bottom of page 7. While you are looking at these rights, what are the techniques that you use? The first and foremost technique was given to us by the constitution makers. Restrictive. Is it restrictive? Is it not? And they use many phrases, subject to, notwithstanding, phrases like that. So the list of restrictions in the text and limits in the rights in question was what the first juristic technique was. Restrictions was to specific articles and crafted to them not susceptible to be transplanted. Where two rights or provisions are of equal status, the interpretation would be to give full effect to them by harmonization. And I think a number of us have stressed what harmonization means. If they are of equal quality, then you will try to give effect from both. Whether Devaru did this or not is another matter. Because Devaru, in fact, said that 26B will be subject to 25 to 2B. But that is for your lordships to decide how your lordship does it. Then, my lord, in using religion comes with what I call balancing. Balancing is a judicial task. We can only assist it. It's the most difficult task that your lordship has. Your lordship goes through it every day. Reasonableness goes hand in hand with proportionality. And then they have been given the last one, which I borrowed from the other side, that law must mean just law. So even if there is a law say of temples, it must be a just law.
Yeah.
If procedures are required, then the procedures should be followed. How your lordship will modulate it, my lord, is up to your lordships. Then, my lord, what I do is on page 8, I give the Cooper argument, and on page 9, the integrity. And then, my lord, why I argued, the argument is reductionist. That's page 10. In the present reference, the propositions of the respondents are plainly reductionist in the following way. The individual right to conscience and freedom of religion is given total primacy. That's a reductionism. In a fairy tale way, it assumes individuals by some imagined social contract create a denomination whose rights are no more than the rights of individuals. This is reductionism. There is a failure to recognize that denominations often are not always consciously created, but emerge over time and predate individuals born to them. There is a qualitative difference between a collection of individuals and a denomination and section of a religion which establishes and maintains institutions, possesses rights of management over, I would say, all religious affairs, own property, and administer property according to law. This is the qualitative difference between a collection of people and a collectivity called a denomination. The institutional rights are derived from 26. When I began, my lord, in my first address to your lordship, I said 26 is the most important right. Without property, without organization, no religion will survive beyond a few months. Because they survive on institutions. They survive on the Pope. They survive on the mosques. They survive on the temples. Take them away and interfere with 26, the very longevity and the future of a religion would completely disappear.
In fact, the denomination or the organization, it holds the people together to a particular philosophy or religion.
Quite right.
Therefore, it is required
Whatever it may be.
perpetuation of religion in this country.
That's right. Because if you want a religion to proceed, somebody has to do it in an organized way with property rights, with autonomy, managing all its affairs. Now, this Guru Swami then said management is different from control. This is just a lexical argument, my lord. I don't even want to reply to it.
Control is part of management.
Sorry, my lord.
Control is one of the part of the management.
Yes, of course, my lord. We can't. It is linguistic quibbling, my lord.
Page 13, you have explained all these things.
And then, my lord, how 26 is limited. I don't do anything. Only thing is sub-Romans 7. Most important, such a change in 26 will totally denude it of its purpose and restructure both the right and limitation. I have already emphasized that. Now, my lord, I come to over the page, if your lordships will come. I'll ignore all this, my lord, if your lordship has time, and I doubt. I come to page 11, bottom of the page. I've changed my view on horizontal rights, my lord. I don't think they can be attached to any other right. They are self-standing. They are universal values. Each of the restrictions are there. Horizontal values can enter into a decision, but they certainly are not a limitation on the rights that exist. We have to make a very important distinction between a value which enters your lordship's judicial imagination and where, like a threshold practice, it becomes a limitation. And the difference between evaluating something and making it a restriction or a limitation, my lord, is fundamental to our understanding of part 3. I'll come over the page, my lord. I will not go into all this for the next 2 pages.
26 also you have well explained.
26, my lord, I have actually dealt with.
Yes.
Your lordship is moving faster than me. Sometimes we call it a sign of impatience. I hope it isn't that.
Because your note is very crispy.
That's very kind, my lord. That's very kind. That's what Mr. Subramaniam tells me, but I don't believe it. Finally, my lord, I come to essentiality and integrality. My lord, there is a difference between a threshold interpretation of essentiality and integrality. Now, what happened in Sabarimala? I'm not enlarging. They said this is not essential to your faith. What was the result? It was a limitation, and they had no Article 25 rights. The 25 rights, if you treat it as a limitation, 25 rights will completely disappear. Likewise, in Sabarimala, if you did not give them denominational rights, 26 disappeared. And this is the importance of the concepts of essentiality and integrity on the one hand, my lord, and, my lord, denomination on the other. If there are threshold requirements, the effect will be 25 rights and 26 rights will be invalidated and they can never have the rights. Beyond that, my lord, essentiality serves no purpose. It can only be devices. One of your lordships may say, look, this is essential. Another may say, this is unessential. Not in the same case. And it has happened. And therefore, my lord, your lordships are not the high pope or the high priests to wander into this particular area. And essentiality and integrality will take your lordship straight into it. The other argument as to how it was evolved, I've already done, my lord. I just want to add two things. My lord, kindly come to page 15, sub 3. This is my interpretation of Durga Committee and Tilkayat. They are arbiter. And the reason why I say that is because the actual decision that was made in Tilkayat was, Nathdwara temple, that he had no rights. He had no anterior rights, therefore they decided against him. Now that is the ratio of the decision. The rest is all a carryover. Justice Gajendra Gadkar, I don't mind saying so, was a reformist, and he saw this opportunity for reformism. Similarly, my lord, as far as the Dargah Committee was concerned, the Khadims raised the question, and once again, Justice Gajendra Gadkar took a huge exploration into history and said, by the way, you never had these rights. So really, these are actually limited decisions if taken to the ratio decidendi. Now, my lord, I am not going to, core beliefs are done. Page 16, my lord, I'm not going to read them because Mr. Jayagupta and Ms. Guruswamy gave certain examples. All those examples are, in my respectful submission, wrong. For example, Ms. Guruswamy said the quarrel was who would appoint priests. Nothing. There was a power struggle taking place. That's what it was. No essentiality was involved. Muhammad Hanif is decided on the basis of animal husbandry. Small part is essential practices. So all those examples, my lord, I'm not going to take your lordship through it, my lord. That's the end of it. But I will take you to one question on page 18 and one table, and then I'm done. My lord, I placed this before your lordships, and so I'm going to place it again, but I'm not going to. While constitutional morality is certainly the creation of Chief Justices Mishra and Chandrachud and others, Chief Justice Chandrachud also gave a decision in the Madrasa case. And the question was whether basic structure could invalidate a statute. And this is what he says. It can be concluded that a statute can be struck down only for the violation of Part 2 or any other provision of the Constitution or for being without legislative competence. The constitutional validity of a statute cannot be challenged for the violation of the basic structure. Here is his reason. The reason is that concepts such as democracy, federalism, secularism are undefined concepts, allowing the courts to strike down legislation for violation of such concepts will introduce an element of uncertainty in constitutional adjudication. Recently, this court has accepted that a challenge to the constitutional validity of in violation of a basic structure is a technical aspect because the infraction has to be traced to the express provisions of the Constitution. Now, if there is relativism in basic structure, it applies to constitutional reality, morality.
But this approach was not applied earlier.
Sorry,
If Justice Chandrachud did not apply this approach in Sabarimala.
exactly. That's the point I'm making.
This is 2025.
The entire generation that has created. I told your lordships that in Narula's case, which was argued by Mr. Dwivedi, he kept saying corrupt judges should not be part of a cabinet. And Justice Deepak Mishra said,
Ministers, please.
MPs should not be part of the cabinet. And what was said by
Corrupt ministers.
and what was said was this: actually, we repose a constitutional trust in the Prime Minister. So morality became a constitutional trust in the Prime Minister. All those have been placed before you, and it was placed very well by the solicitor, because he made our task much easier, because he read everything. And the one good thing that he read, while everybody was quoting passages from the Constituent Assembly debate, when he quoted a passage, he said, this was not agreed to by the Constituent Assembly. The decision is as important as what they said, and that made it our task easier. Now I come to the last, my lord, the extent of judicial review. What I've done here, my lord, is I've put down the article, the prescribed limitation. My Lord Justice Bagchi has it. So Article 25(1), I've given what it is, what the prescribed limitation is. I'll just take two examples and it will help. What must the court do? Judicial review in each case will be different. Not case by case, but class by class it will be different. The court must examine A, whether the claims are based on a bona fide belief. If not, the case goes out. Next step, interpret the extent of the freedoms guaranteed. Interpret the prescribed limitation. Apply proportionality. Ensure that the law is fair and just. Give due respect to directive principles where applicable and as reflecting the values underlying the Constitution. Now, what I've done is, for each one of these, I have in fact indicated how your lordship can proceed if your lordships are so advised. And my lord, it is not a question of how high or how low the judicial review is. The question is, what is the judicial review in this case? My lord, I've taken a lot of your lordship's time. I'm extremely grateful.
Thank you, Mr. Ram. Thank you. Vivek. Who yesterday did not turn up very difficult for. We can't accommodate now everyone. Yes, Mr. Dwivedi.
Well, I have a very short note, so it won't take much time. Let's see. In some ways, Lord, I'm responsible for this constitutional morality. I wanted the corrupt member of parliaments not being made ministers, Lord. So I wanted to restrict, not judges. The argument was that when the Prime Minister selects the ministers, then he
We
should
reflect that
look into this, because what are we going to have, if every corrupt...
Dhawan also meant that,
Yes,
but sometimes the words are so.
but I did not know, that this will be the slide of this constitutional morality. It intervenes everywhere.
We hope it was only a slip and not intentionally said.
Yes. Because just two caveats. One, Dr. Dhawan Malan cited a quotation from the esteemed learned counsel, late Mr. Wali Nariman, where he says, Hinduism is a way of life. But I disagree with this. All religions have a way of life, but they are much more than that. Hinduism is a religious philosophy also. It presents a social structure also, how man relates with the creator. So it's so much more. What is the man's existence in this world? So this crept in one judgment of this court, the Hinduism is a way of life, and that appears to be from where Mr. Nariman picked it up. I hope your lordship will not endorse that, that is simply a way of life. That completely dilutes the essence of Hinduism. And the second, is with something which I agree, completely, that 25 and 26 are group rights, in fact, massive group rights. But 25(1) is a fundamental right, where the individual right and the group right coalesce. They stand intertwined. Because I had earlier said in the main argument that religion is associational by its very nature. But one man in Robinson Crusoe's island, he can't. He may do meditation, etc., but yoga, but it can't be a creation of a religion. So all these religions which are existing, they are associational in nature. And conscience, practice, propagation, all these can be exercised by groups. Groups are nothing but collection of individual judges. That is what Lord Shirur Mutt said. In fact, when it was argued that institutions don't have, they said the question doesn't arise, but what we think is that even in institutions, it is individuals who carry on. It's a collective conscience. When people group together, then it becomes a collective conscience. So it is both an individual right. The practices can be done at home individually. It can be done collectively by me in the temples or in the mosque or in the church. So, but predominantly it's a group right. The fact that individuals can also exercise these rights individually, that does not mean that it ceases to be a group right. And when we talk of 26 religious denominations, that's a narrower subset, which, because of the historical significance, which your lordships have all heard during the course of arguments on our side, because of that reason, my lord, they were given special status as a fundamental right with special additional protections. They were taken out from that. So non-denominational institutions will still be under one. It is only denominational. And denominational, whether we call it sampradaya or otherwise, sampradayas are in all languages. It's not simply Hindi. We need not go to Hindi dictionary, English dictionary. Sampradaya exists in Tamil also, in Kannada also, in Malayalam also. All languages. And as Justice Sabarimala said, even Muslims have sampradayas. So sampradaya is not something which is an abhorrent word, and therefore religious denomination is really meant to be that only. And because of that character, these special rights have been given. And I had urged earlier, which I reiterate, that it should not be diluted, It has played a great role in keeping Hinduism alive and the nation, my lord, building. Now, with these two, my lords, in fact, my lord, in my humble submission, every individual right which is there in part 3 also simultaneously in an intertwined manner has a group dimension. One doesn't speak, my lord, or express oneself in an isolated room. One also speaks, my lord, when in seminars and associations, in parliament, in court, my lord, it's a group right also. And it is meant to generate ideas, my lord, which are useful for the nation. And that's why, my lord, these individual rights are given. So there's an interaction of individual and group everywhere. If I may only advert, my lord, to two expressions, one is in African, my lord, and one is in Sanskrit. In African, they say, my lord, Ubuntu and Gamuntu and Gabuntu, which means, my lord, I am because we are. And in Sanskrit, my lord, it's a reverse way and a better way. Vayam smaha tasmate aham asti. We are, therefore I am. So the group comes first. And because of the group, I am. And in English, one can also say, Lord, that who lives if the nation dies, Lord. So the group, Lord, ultimately in religion also, if the religion is to be preserved, the group entitlement is of immense significance and it should not be diluted, Lord. With this, my Lord, if I may come back, my Lord, to one of the questions which my Lord Justice Nagaratnam, Lord, had raised. And I must confess, my Lord, that we should have put more effort on this question as to what is the significance of subject to other provisions of this part. The first, my Lord, is that when we are faced with this expression subject to or non-obstante, then we do not, my Lord, immediately conclude that whatever right is being conferred by the following words or recognized by the following words stands immediately subjected to everything which is in part 3. In the context of non-obstante clause, your lordships have said in judgments, Lord, that don't start with it. Look at what is being provided as substantially provided in the provision.
What follows?
Yes. What follows is the primary thing, and then you can determine, my lord, what is subject to and what is non-obstante. If your lordship comes to page 17, this is 11 judge judgment, my lord, Mother of Scindia's. Para 68 I have quoted. The article commences with the opening words, notwithstanding anything in this constitution. These exclusionary words are no doubt potent enough to exclude every consideration arising from the other provisions of the Constitution, including the chapter on fundamental rights. But for that reason alone, we must determine the scope of that article strictly. The article goes on to say that jurisdiction of all courts, including the Supreme Court, is barred except the President may consult the Supreme Court. Having said this, the article goes on to specify the matters on which jurisdiction is barred. This it does in two parts. The first part is, in any dispute arising out of any provision of a treaty, etc., which was entered into or executed before the commencement of this constitution by any ruler of an Indian state to which the government of Dominion was a party, and which has or has been continued in operation. This shows that a dispute relating to the enforcement, interpretation, or breach of treaty is barred from the court's jurisdiction. The word arising out of the provisions of treaty limit the words. Thus, if treaty covenant is characterized as forged by any party, that would not be a dispute arising out of provision of statute. So they not first spell out what is the context, what is the content of the substantive part, and then will
Which was that article?
That's on different context. It's here, notwithstanding anything, therefore, you have to consider.
So it doesn't override everything. That's what I'm trying to say. I will come to how we should apply to subject to.
Subject to.
Yes. Just have one paragraph also of the next judgment, Lord. A non-obstante clause is generally incorporated in a statute to give overriding effect to a particular section of a statute as a whole. While interpreting non-obstante clause, the court is required to find out the extent to which the legislature intended to do so in the context in which the non-obstante clause is used. So this is what I want to emphasize, that when we come to 25(1), please see what is the content of 25 or this fundamental right. For it is this which is being subjected to. All persons are equally entitled to freedom of conscience and the right freely to profess, practice, and propagate religion. So it's the equality. All persons are equally entitled to, it is that. So one necessarily, therefore, when it says subject to, then one has to trace out those provisions which necessarily have an impact on this equality which is being talked about in this. For example, 17. 17, my lord, is an article which is an article of equality. When it prohibits untouchability, it brings in, it's an inclusive provision, and because of the seriousness of the exclusion, it makes it an offense. So prohibition coupled with offense, that's why, my lord, it has an impact on equality, and it has to, this has to be subject to 17. Likewise, nobody can say, my lord, that any religious denomination or otherwise any religious institution can, despite the constitutional injunction in 17, still practice, my lord, this untouchability. That cannot possibly be argued, my lord. Therefore, it immediately gets attracted. Likewise, 23. Many religious denominations.
Interrupt for a moment. On these horizontal rights, what I indicated was that they would give rise to a constitutional tort.
Yes, yes, we saw that. We saw that, I know. Therefore, only suit will lie.
But I didn't emphasize it. I'm sorry to interrupt.
So Article 23, it cannot be said, my lord, that a religious denomination which has large amount of land, my lords, they can practice begar there, my lord, employ people and not have forced labor there. So therefore, these are provisions which impact equality and therefore will apply. It's not, my lord, that all other provisions of the part 3 straight away will apply. Article 30 cannot apply. There are provisions like Article 14 and 15(1) which are injunctions against the state, and therefore, my lord, on the face of it, it has no application to the equality fundamental right which has been conferred. So once we, my lord, identify this context and the equality principle which is enshrined in Article 25(1), then it becomes easy to locate, my lords, without entering into this horizontal and vertical aspect. It's the germaneness to the equality. If it is germane to it, it will have application. Either it will improve upon it or it may dilute it, whatever be the effect of it. For example, 16(5). It says Parliament can make a law, my lord, saying that in case of religious denomination institutions, only a member of that will be appointed. Now that's an improvement. So subject to doesn't necessarily mean, my lord, a dilution, a reduction. It can mean an enhancement or an improvement upon the equality principle. So it is only such, my lord, articles in my humble submissions, this subject to other parts. And the second aspect of this is that when subject, this should be read as a whole, subject to public order, morality, and health. Because this is an empowerment to the legislature to make a law with regard to these 3 subjects. So identically, if you read it as a whole and to other provisions of this part, so therefore there has to be some provision in the other part of this part 3, which empowers the legislature to make a law.
Is there in 25(2)?
Yes.
Under 25(2),
25(2) is there.
they can make the law.
Yes.
That is the enabling power of the state.
Yes. Yes.
So that's this humble submission on this aspect. Then, my lords, I have, my lords, just pointing out to your lordships, note in page 3, referred to 4 competing structures which have been presented for acceptance. The first says that Article 25 relates to individual right to freedom of religion. I have already submitted, my lord, that it is coalesce. Article 26 is concerned with group or collective right to religion. Article 26 is not a standalone provision. Article 26, despite not being subject to 25, would have to be harmonized with 25(2)(b).
I think
This is the Devaru.
your contention comes in page 11.
Yes, I'm just pointing out that these are the four structures.
Yes, that's what you're telling.
Yes, that's right. I have a problem, Lord, with this first structure of Devaru, Lords.
First, second.
I have pointed out the fallacy.
First, second and third, you do not agree.
Yes, sir.
You are disagreeing. You are agreeing only with the fourth structure.
The reason is, my lord, that to harmonize states' power, enabling power to make a law with a fundamental right is basically
Correct.
inherently
Yeah.
incorrect concept, my lord. So unless, my lord, we say that there is some element of the fundamental right to religion, even with regard to religious denomination, which is embedded in 25(1), 25(2)(b), my lord, cannot operate to bring it through a backdoor of harmonization. Because please see, Lord, this is significant because if you apply this harmonization principle between a fundamental right and a enabling lawmaking power, then kindly apply it to 19(1)(a), my lords. Then we are, my lord, harmonizing with 19(2). What is the correct approach is that if a law is made by the legislature, it will be tested whether, my lord, it is related to the head, whether it is reasonable, not disproportionate, not manifestly arbitrary. So there's no question of harmonizing states' power to make law with the fundamental right.
The way that actually helps you.
Yes.
Supposing in the law which has been enacted under 25(2)(b), you can still go under 25(1) and say it affects my right. To that extent, actually, it helps you.
So for religious denomination, no, I will be invoking as a religious denomination 26. My case is, my respectful submission is that the religious denomination has been carved out and given additional special rights under 26. 26(b) particularly.
Very good.
So when confronted with 26(b), how does we bring in Lord and harmonize the two? It's much better to achieve the result, Lord, by the structure of mandatory injunction of 17, etc., and morality.
It is on the premise that we agree with you that 26 is a standalone.
No, it may not be standalone.
So far as application of 25(2)(b) is concerned.
May I say this, Lord, with respects that no provision in the Constitution is standalone. Ultimately, all provisions taken together make the constitutional system.
You are
So
also
merely by saying 26,
page 13, serial number 7, you also say 26, you not stand alone.
yes, I am saying that nothing emerges from this expression, my lord, that it is standalone or not a standalone. Ultimately, one has to see, my lord, how do we limit it? What are the limitations on 26(b)? Can we bring in 25(2)(b) by a roundabout manner way or by harmonizing 26(b) with that? That's my humble submission.
That time the particular legislation has to be seen.
That's
Then whether it is really encroaching upon 26(b) or it is an instance of social reform has to be weighed. That is where the harmonization comes.
So
Whether it is an instance of social reform under the Act or
that's right.
in the guise of social reform, there is an encroachment.
So what I am suggesting, what I am respectfully suggesting for
You have to balance.
well, the question of harmonizing doesn't arise, my lords. They are not co-equal fundamental. Harmonization will arise, for example, my lord, if 29 and 30 will not have to be balanced. 29 says, my lord, that nobody will be restricted from admission. 30, so then two fundamental rights you can balance. But fundamental right and legislation, harmonization doesn't come in when a law is made. The lordship will judge, my lord, is it reasonable or not? Is it following up 26(b) or not? So that's a different kind of a approach and test.
Gopal and Mr. Dhawan has also argued
Yes,
that
yes.
harmonizing question arises only when you perceive some conflict.
Yes.
There is no conflict where the question of harmonizing.
And to say, because Devaru says there are two co-equal provisions. So lawmaking and fundamental right to make it co-equal and then start harmonizing. So that logic, Devaru is correct on principle when it says that the law made in that case was good. because it was a public temple open to everybody, and therefore, my lord, and 17 is there, and therefore that logic part is correct. But when it tries to, my lord, bring it through this route and say co-equal rights, and then harmonize the two, that I submit, my lord, is fallacious.
Considering the validity of that particular law, there has to be a consideration of 25(2) and 26(b). There the harmonization comes.
So,
In
lordship,
the context of considering both the articles. You can't ignore 26(b) while consider and only say it is social reform and therefore uphold it.
lordship will
At the same time, you can't ignore 25(b) and say I will consider only 26(b) and I will strike it down.
so that
Harmony is in the
so
consideration.
that's a question of proportionality, my lords.
Consideration.
Is it excessive? That will be the question, my lord. Once a law is there,
We follow that.
it falls under the head, then the question will be of excessiveness, my lord. That's my humble submission.
Thank you, Mr. Dwivedi. One line if you want to say,
Just-
please. Yesterday,
Just one aspect, my lord, I'll not read it. I have, my lords, at the end, there was some effort to draw a limitation from the preamble, my lords. The preambular values. It was said, my lord, that limits Article 26B,
page 21.
which is at page
Yes, you have it.
21.
You are only one. You said no power.
Yes, and I have, my lord, from Keshwan and Bharti, I have quoted, my lord, from the various judgments
Yes, yes,
at page 22 and 23.
yes.
Which they say you can use it only where there is some ambiguity in some provision to understand it, but not to impose. It's not a source of power.
Yes, sir.
It's not a limitation.
Thank you, Mr. Dwivedi. Thank you.
That's, just 25(2) begins with nothing in this article.
Yes.
Just that,
Yes,
because for the sake of completeness, my lord,
Yes, sir.
I'm very sorry to jump up. My bones don't permit it, my lord.
I will take 2 to 3 minutes to 5 minutes.
Huh?
3 to 5 minutes, I may be allowed.
1 minute only, please. 1 minute.
Minutes, 1 minute, it may not be over. I respectfully submit. It is on Article 290A. 290A, the disbursement of the funds from the monies from the consolidated funds minutes cannot be applied to Sabarimala because it is an unincorporated devasum. In that context, minutes, the 2 sections of the Travancore Devasum Act, TCHRI Act, may kindly be seen. Minutes, Section 2,
Like, we will examine it. You can give it.
after lunch minutes.
We will consider.
After lunch minutes only, 2 minutes only.
Yesterday, nobody turned up. We kept on, we were sitting till 5 o'clock. Now suddenly again people have started.
That's
So, we see one line only.
Yes, it was one line. Let's, my
We will
submission,
examine,
3 minutes may be agreement.
we will consider it your note. You want to say something more?
Yes.
What do you want to say?
Because I could not be present yesterday because of my position. I was in the hospital.
Okay.
That is why I'm pleading.
So you must have said everything in the note.
Beg your pardon?
You are giving a supplementary note today.
Yeah, I'm giving a supplementary note.
Huh.
I'm giving the covenant entered into by the Maharaja of Travancore and the Maharaja of Cochin in the matter of governance of this temple under the guaranteeship of Government of India.
So we will go through it.
Someone brought you a notice already yesterday. You were not there. Somebody has brought you a notice.
And Section 30 of the TCHRI Act also
That
dealing with the
specifically agreed
unincorporated
between them that they should fund it.
unincorporated temples. And Section 26(2)B, Lordship may kindly see, will not take away the character of this family temple, which falls under 26(b) of the Constitution. This is what I would like
We
to.
brought to our notice about this Article 298.
No, this,
Yes.
this Shraddha Deshmukh.
Can I hand over?
Yes, yes.
Go on.
Are you
Yes.
let the note?
I'm handing over.
Yes, we will examine it, Mr. Radha. We will consider it.
Thank you very much.
Yes, Mr. Joshi, one line.
Mulaj, the only submission is, Mulaj, we are for the community. This is the community of Tiruppan, Alavar, Amal community, which is a religious denomination, and the right is a pre-constitutional right, Mulaj. The submission was made that this is not a pre-constitutional right, and therefore, Mulaj, this right which comes from the Entry Protection Act, Mulaj, from there the community has got the right. Now, Mulaj, that right comes with a duty. And therefore, the duty is to ensure and protect, my lords, the sovereignty and the nature of the God which is there, or the deity which is sitting over there. That right has to be protected. Because in my note, I have also covered Keshwan and the Bharati, my lords, where Justice Sikri's 2 paras may be relevant.
All right.
Not emphasizing more, my lords. My note.
All right,
is that.
thank you very much. Now
Right.
from the both sides, the arguments are over. Mr. Prameshwar, immediate after lunch, 2 o'clock.
Can we just enter a written submission, lordships can consider?
Yes, you can give any note that we will in the last